Be ready. Start. In the case before us, the base on which the tax operates is not the manufacture but the commercial transaction of sale and purchase of the commodity which has to be used in future in a manufacturing process, with the result that by no stretch can be the imputed tax be considered to be an excise duty stop. Not only is it not possible to describe the tax in question to be unrelated to and not dependent on any commercial transaction of the goods taxed, but on the contrary, the tax is essentially and in pith and substance imposed on the base of the commercial transaction itself, though the purchased goods are intended to be used later for manufacturing some other goods stock. Without the sale and purchase of the goods taxed, the imputed tax is not intended to operate, and the event of manufacture or production which alone attracts excise duty has not yet occurred, with the result that the manufactured goods have not yet even come into existence. Stop. In these circumstances, can it be said that the tax in question is a duty of excise on goods manufactured or produced, and the impugned legislative measure is therefore a colorable piece of legislation? Stop. In my opinion, the only possible answer can be in the negative. Stop. The petitioner's argument that the tax, being qua a manufacturer, must be considered to be excise duty suffers from the obvious fallacy that he assumes that excise duty can take the form of tax on purchase of goods which are to be used later in manufacturing some other goods, as assumption for which, in my opinion, there is absolutely no justification. Stop. I therefore unhesitatingly repeal as unsound the contention that the impugned tax is in pith and substance an excise duty which is being levied by the state legislature under the device of purchase tax, and that for this reason the law in question amounts to colorable piece of legislation and therefore ultra vires. Stanza. The next challenge is to the constitutionality of the entire act, though the real basis of this wholesale attack is that Section 5 of the Act has been held by a bench of this court to be ultra vires, and that being the real charging section, the whole of the statute must be held to be ultra vires and outside the competence of the Punjab state legislature, with the result that unless whole of the statute is reenacted, mere amendment of Section 5, which has admittedly been effected, full stop, over.